Good morning, Monday, May 27th, 7:43. It's been more than 6 years now since that horrific Humboldt Broncos bus crash. And last week, the man driving the semi-truck has been ordered to be deported. An Immigration and Refugee Board hearing was held virtually in Calgary for Jaskirat Singh Sidhu on Friday morning, where that decision was handed out. Quote from the Immigration Division of the Board: "I can't consider humanitarian and compassionate factors here in this situation." Says, "My sole role is to make a finding on whether the minister has established the facts that support the allegation that you're inadmissible for serious criminality, and I'm satisfied that the minister's report is well-founded." So let's talk about this situation, what this means, how long the situation might take to unfold, especially when we're talking about a family that's being broken up here as a result of this. Understand that the child of the truck driver here is born in Canada as well. So let's get into all of this. Joined on the line now by Acumen Law's Kyla Lee. Kyla, good morning. Thanks for the time. And I guess surprised at all by what came down in terms of this ruling, or was this kind of what was to be expected, especially based on the media attention that this story is and will continue to receive?
It's not surprising, although not as a result of the media attention that the story's received, because by and large, the public seems to be a little bit shocked that somebody in this situation is being deported. I mean, they did everything right. They remained at the scene. They cooperated with the investigation. They expressed remorse. They accepted their responsibility for the incident, pled guilty at an early opportunity, and served their sentence. This is what we as a society demand. But the government always wants to take things one step further when it comes to people who are convicted of criminal offenses. And because Mr. Sidhu is a permanent resident, he is subject to automatic provisions under the Immigration and Refugee Protection Act that make him inadmissible to Canada, so must be removed from Canada as a result of serious criminality.
Yeah, I guess, it seems to me that the families of the victims in this case are almost more compassionate about where we stand on this situation than you get from the general public. Why can't those kinds of factors really be taken into account, or do they when you're looking at these kinds of decisions? Because it certainly doesn't feel like it.
They aren't taken into account in these types of decisions. And the reason for that is that this happens basically by operation of statutory provisions. There were amendments that were made to the Immigration and Refugee Protection Act several years ago that made people presumptively inadmissible to Canada as a result of criminal conduct, regardless of whether or not Canada says, we embrace you as one of us and we want you to remain here, regardless of whether or not you have a family here. There are still avenues to allege humanitarian grounds in certain circumstances. But most of the time when the deportation hearings are taking place, it's really just, is the law making this person inadmissible or not? And is there a pathway to their admissibility?
Yeah, and how does the family, I guess, situation factor into how this will progress moving forward in terms of how quickly, I guess Mr. Sidhu could be removed from this country? I'll get to those kinds of questions about that side in a minute. But yeah, how does the family factor into this? In what way? I can't imagine it's completely ignored here.
No, it's not ignored. So once a person is sort of ordered to be removed, then there are steps that have to be taken to actually put that removal into place. So there are certain hearings that take place. There's a sort of a pre-removal risk assessment to determine what happens to a person while they're waiting to be removed. You can't just put somebody on the next plane, back to where they came from and say, okay, set up your life. You've got to give them sort of some opportunity to make arrangements for somewhere to go, or monitor them in the community while the two countries are making arrangements for the person to be returned back to their country in which they have citizenship. And so in these circumstances, there's a risk assessment that takes place to determine whether the person's held in, pre-removal detention, or whether the person is sort of put on essentially immigration bail conditions in the community. And having a family and ties to the community, working, having children, all of those things would support being able to be in the community and continuing to live among Canadian society on conditions. So it does get taken into consideration at that stage.
What about the actual child in this situation? I mean, born in Canada to permanent residence here. Like, how does a decision get made on that? Is it up to the family to say, hey, you're coming to India with us, or if you stay behind?
It is up to the family to say that. I mean, once a person is born in Canada, that person gets Canadian citizenship. So the child is not eligible for deportation in these circumstances. And, usually in these situations, though, when you have a parent, and generally speaking, a sole provider parent, they're going to be making the decision as a family to take the child back to India with them.
Yeah, that's a tough spot, especially like I'm reading from statements that this child suffering, lung and heart issues at an early age here. And, if you know what's going on in India where it's like 54 degrees, I can't imagine that would be a good spot for a kid suffering from any problem. Well, just anybody in general, let alone if you have medical problems right now. So just factors like that will play a difficult role in how this family does indeed move forward. Okay, so yeah, any like possible timelines, I guess, on this, or is this something like, because you've kind of laid out some potential, issues and processes that have to go through, but how long could this take to work its way through?
This could take months or even years, especially because, as a permanent resident, there are, some sort of limited avenues of appeal and ways to have your status considered. Those sort of hearings and those applications can take more time and can sort of suspend the deferral, which will probably be avenues that are pursued in this circumstance, particularly because of the needs of the child. Whatever you can do to prolong your stay in Canada to continue getting the medical care that we have here in the climate that we have here, and keeping the child in, the circumstances that they've only ever known, is in the best interest of the child. So I can't imagine that the parents in this situation are going to do anything that isn't in their children's best interest. Yeah.
Is there any opportunity to appeal something like this, or is that, the decision's made and you got to kind of live with it here?
So there, are opportunities to appeal decisions in the sense of, these are ministerial orders, so they can be judicially reviewed. But where it is a situation of, a person, a minister acting under a statutory power that has very little discretion associated to it, there's usually not a lot that can be argued as far as a successful appeal. There is a possibility, that a constitutional challenge could be brought to the law itself requiring deportation, although I get the sense, just given how everything has played out in this case thus far, that that's not something that Mr. Sidhu has an appetite for.
Here with Acumen Law's Kyla Lee. I just wanted to ask one quick question just to kind of deviate away from this on the Surrey police decision that was made last week. The BC Supreme Court overturning the City of Surrey's judicial review petition aimed at stopping Public Safety Minister Mike Farber's decision that the RCMP must be replaced by the Surrey Police Service. We had a conversation when that challenge or that judicial review was first filed. The City of Surrey says it will now continue to transition to the Surrey Police Service. From a legal perspective, because this story obviously is far from being over, unfortunately, but from a legal perspective, is this story officially done now?
It's not officially done. There is still an avenue for appeal, and an appeal of a judicial review decision is, something that essentially gives them another kick at the can. I think the difficulty that they're going to have is, it's from a legal perspective, it's a relatively short decision. It cuts to the point as far as the constitutional challenge or the Charter of Rights issued. The judge said exactly what I said to you previously, that this isn't free speech violation because your free speech doesn't guarantee you get what you want as a result of the speech. And, the government wrote the legislation in a way that allows them to essentially have a lot of control over these processes. And so I don't see, reading the decision myself, anything that would likely be sort of a successful avenue of appeal on a judicial review appeal. But, I leave it to other lawyers to be more creative than me.
Yeah. Well, at least the way it's gone to this point, anything that can be tried will be tried. That's the way it seems to go. So we'll see what happens, but I'm just kind of getting tired of it, but I'm probably not as tired of it as the people of Surrey are at this point. Appreciate this, as always, Kyla. Thank you so much for it.
Thanks for having me.
Acumen Law's Kyla Lee joining us here on this Monday.